Good morning, everyone. Thank you for taking the time to join us for what I think is an incredibly important webinar briefing session. So, just a minute ago, the DTIC published three documents of tremendous importance. They've published proposed amendments to the International Trade Administration Act. This is the act that gives rise to ITA and sets the rules for what ITA can and can't do and how they should do it. They've also published proposed anti-dumping regulations, amended anti-dumping regulations, and amended safeguard regulations. So these are incredibly important instruments in the kind of trade policy space. Now, there are a couple of things that immediately strike us as problematic, which I think are important to pay attention to. The first is there are some other bits of regulatory material which has not been proposed for amendment. The one is our countervailing, which is our anti-subsidy instrument. Now, this could be because since South Africa joined BRICS, we've stopped bringing countervailing actions, largely to make sure that we don't upset China. And the tariff regulations, which we believe are fraught with problems, have also not been proposed for amendment. In fact, it's not an ideal situation to be amending these piecemeal. But be that as it may, here we find ourselves. Now, before we get into the content of what is being proposed here, there are a couple of things that concern us right out of the blocks. The first is that when legislation is typically amended or proposed for amendment, the process is let's get comment from people who have something to say. So let's call for public comment. What do you think should be amended? Then when the proposed amendment itself comes out, you would usually have some kind of memo. I'm sure Clive will give you the technical name for that, but you'd have a memo that comes out that says, here's a list of the things we are changing and why we are changing them. And then you would typically just be given the proposed amendments. So they would simply tell you, we're going to add this section, remove this section, and so on. That has not happened here. Instead, what we've been given are just three, I should say, brand new documents. And in other words, you have to kind of off your own bat, take the old bit of legislation, the new bit of legislation, put them next to each other, and see exactly where the changes occur. And some of the changes are subtle. It's a word or two here and there. So this is really not a good way to take comment if you actually want people to meaningfully participate. But this is the first issue we've run into. We've already raised our concerns around the issues I've just mentioned here with the minister and with Mr. Amarain from ITA, who's the person responsible for the amendments. I think it's absolutely crucial that these be published in a way that allows for proper, meaningful consultation with the public. So why are these amendments so important? And I say here, it doesn't matter which side of a case you are on, whether you are bringing an application for more protection in the form of an anti-dumping case, or you are responding to one. What everyone wants is an incredibly predictable process. You want to reduce the amount of discretion that anyone has to do whatever they wish. And you want the investigation to be largely based on empirical information. The very opposite direction of travel is occurring here. So we're seeing considerably more discretion, more areas where you can sit down and negotiate. And I think that's just generally bad practice. In the same way that you don't want to be stopped by the Metro Police and somebody can negotiate their way out of a drunk driving charge and then run over a child or something. So we want to be in a world where these sorts of investigations, which can be incredibly intrusive into the market, are done in a way where the process is properly respected. There are also lots of things that are left out of here. So it's one thing to propose a set of amendments, but they're really big issues, which, for example, have been settled in court cases that just do not make an appearance. And Clive will dive into a lot of that sort of detail here. But the things that stand out for me, at least, is number one, we now have national security in a very vaguely defined way as a reason for ITAC to be able to impose a tariff. Now, it could be a tariff in the form of whatever instrument, but national security is now explicitly noted as a factor which was not here before. The other big factor is foreign trade practices. Think here, if you guys are aware of it, of what the EU passed a couple of years ago, where it says, look, if you've got one country that is deliberately having a swing at them in an unfair way, that they can protect themselves. We have reciprocal commitments. For those of you who know me, I think these reciprocal agreements and commitments have absolutely no place in our trade policy. However, they are now being proposed to get slotted into the Act. And that means that they can be applied not only to tariff matters, but also to things like trade remedies. So you could find yourself requesting an anti-dumping duty and realize right afterwards that you now have commitments to make. So we don't know the detail again. The big and intrusive proposals tend to be very light on the how. Be that as it may, I'm going to hand over to Clive at this point. Clive is our head of research. He's also a trade law professor. Professor Vinti, do you want to take it away on the proposed amendments to the Act?
Yeah, Donald, thank you very much. Good morning to everyone. So I think just by way of starting, so I'll focus on the changes to the Trade Act. I think that what we have gleaned so far from the Trade Act, because typically what would happen, as Donald had explained earlier on, is that when you want to amend a statute of Parliament, you would publish an amendment bill. Now, in the amendment bill, you would only focus on the provisions that you're amending or the provisions that you're adding to the statute. So you wouldn't do what has happened here with the DTIC and ITAC, where you get the whole Act again, and you have to work it out from the Act what changes are there. Now, to be fair, the minister has given us a note to explain, to just highlight what the changes are, but that would not be sufficient in this context, unfortunately. But what we would have expected from the DTIC and ITAC would be that they would prepare an actual amendment bill that gives us explicit clear clarity on these are the particular provisions that are changing, and these are the extent of the changes. We're taking away this provision, we're adding this particular provision. So from what we can gather, based on just the practice of amendments to legislation, these are the changes that we see coming out of the Act. But definitely there should have been a bill that clarifies what changes are being done. And secondly, there should have been what is called a memorandum of the objects of the bill. So the memorandum of the objects of the bill takes away the confusion about what they're trying to do. So if you have an amendment bill, it will tell you only the changes that are being done so that you don't get caught up in what we are in now, where we're trying to figure out what the changes are. The memorandum tells you what exactly they mean by each provision. So it will be essentially a commentary done by ITAC primarily in conjunction with the TTIC, explaining each particular amendment. If they've amended a provision, they'll tell you why they've amended it. If they have added a provision, it will tell you why they've added it. So those two documents being the amendment bill, focusing only on the amendments, and secondly, a memorandum would then tell you what it means. Because what they try to do with a memorandum of the objects or of the amendment of the bill is that they're trying to fill in the gap whereby you're not sure where did this change come from and what do they mean by this? Because the problem with legislation normally is that once it is drafted by Parliament, right, when it finally lands in the real world, no one actually knows what Parliament was thinking. So the only time for us to know what Parliament means with a particular provision would be that it goes to court or you have an interaction with ITAC or the DTIC. So because of that particular gap that would occur in practice, the memorandums were created so that you can actually know what Parliament meant. What is it that was meant to be done when we came up with this provision? So anyway, that's just to give you a background. So let's jump right in. So the biggest change, obviously, very big one, pernicious provision, is the addition of Section 6A with a capital letter A, which is one of the ways you pick up an amendment. You would see the numbering of the particular section having a capitalized alphabetical word. So Section 6A is the new provision on national security. So here, the minister can direct ITAC to investigate if imports are having or likely to have an adverse effect on the national security interests of the Republic. So what does this really mean? What this simply means is that there doesn't have to be a threat to national security, which is not defined, by the way. There doesn't have to be an effect on national security. Even a threat is sufficient. So either a threat, right, to the national security, or an actual breach of national security. But the nature of the breach must be one that is adverse, right? We're not clear what that means in terms of what do we mean by adverse, but you can see that the language, by my estimation, is borrowed from the Competition Act. So the Competition Act has a section on national security, which I think still has not kicked in, dealing with measures by foreign acquiring firms. And I think the language of our national security provision in the Trade Act might have been borrowed from there. And if you look at the factors that you're supposed to consider on whether there's been an adverse or a likely adverse effect on national security, they largely mirror the national security test that is in the Competition Act, the Section 18 I just spoke about. Now, you see there I've listed a few factors that are to be considered. It's not the full set. There's about 6 factors that are listed in Section 6A. The reason why I've just picked out those 3 is because the list that we have been provided for is not a closed list. So what does that mean? It means there can be additional factors. So the most prominent ones we see is domestic production capacity, supply chain dependence, critical infrastructure. But there's other 3 factors which I won't mention now that sit within that provision that will be considered by ITAC in their investigation. What's important is that ITAC is going to have to liaise with the Department of Defense. It's going to have to do public hearings. It's going to have to read and implement our national security policies, like the recently published National Security Strategy. So they're going to have to go to a whole new world that they've never actually worked on, because this is typically work that is reserved for the security apparatus. So if you compare what ITAC investigation is going to have to do to what the Competition Commission approaches, under the Competition Commission, when there's a national security threat, what would actually happen is that there is a committee that is chaired by the president of the country, together with the security ministers, right, from the security cluster and the various other officials. There's a clear understanding under the Competition Act that the determination of national security is best done by people who have experience in the sector. In the trade sector, when you look at the national security provision here, we've taken a different approach. ITAC, which has no clear experience on national security, is going to take the baton forward. And of course, this brings to light, if you remember with the steel tariff review, ITAC had made a determination that there was some suggestion that there should be an assessment of national security implications, right, in terms of the steel tariff structure. And one of the issues we've raised is, how does ITAC have competence? And this particular amendment, proposed amendment to the Act, confirms that in fact ITAC has unfortunately no business making any assessments on national security, because it's simply just not allowed, right, under the current Act before the proposed amendment. So our thoughts on it really that this is going to be a significant power. At present, obviously, like I said, we don't know what national security means. The factors that we've been given are not a closed list, and those could change in time. I think let's go to the next slide, Donald. So the second other big change is the public interest ground. So public interest has always sort of been an implicit in and out provision, but it has never been explicitly provided for in our Trade Act. But now we're going to have in Section 16(4) an addition of the public interest ground. So what does this mean? It means that in all investigations, right, in all investigations, in all reviews, there's going to be consideration of the public interest. So when ITAC wants to decide on whether they should make a duty change, whether they should offer duty protection, whatever it is that you're seeking from ITAC, they will have to make a decision that is in the public interest, right? So what's particularly important about public interest, at least the factors we've been given, there's 3 factors that are relevant. They'll assess what is the impact on consumers, what is the impact on downstream users, and what is the impact on the broader economy. But similar language is used under the public interest ground as is used under the national security clause. What do I mean by that? I mean that the grounds that are used to consider whether something is in the public interest or not are not closed. So it could be any factor at the time that ITA deems to be relevant. So when we consider national security, under Section 6A, the proposed 6A, and when we see public interest, what the factors are in the Act are not a closed list. It could be any factor that ITA deems to be in the public interest at the time. The next slide, Donald. Donald had already spoken to this, that we now have reciprocal commitments for all ITAC investigations, reviews, and agreements. Now, what's important about reciprocal commitments is that they used to be a requirement that's solely set under the tariff investigation regulations. So if you went into ITAC for duty protection under the tariff regulations, you could be required, and I use the language you could, meaning it's not always that you'd be required to make a reciprocal commitment. We don't know what makes ITAC decide that this particular firm that is applying for duty protection should make a reciprocal commitment and why another firm should not do it. That was one of the lingering questions that we had under the tariff regulations. Now, the Trade Act itself didn't provide, didn't explicitly, I think, by my estimation, provide for the issue of reciprocal commitments. It was an instrument that came out, I think, in Regulation 10 of the tariff regulations. Now, ITAC have seized on this. They've put it now in the Act. So in the new proposed Section 16.5, you will find that they have included reciprocal commitments as part of any investigation or any review that ITAC is going to do. So then when you then go for duty protection, whether it be a trade remedies, meaning dumping, safeguard, or countervailing, or whether it be like a tariff investigation, you would be required to make a reciprocal commitment. But like I said, the language there is discretionary, meaning sometimes they may do, sometimes they may not. We still don't know. But the commitments you'll have to make are either on output, investment, employment, prices. Could be all of them, it could be some of them. We do not know. We do not know why a particular firm, when they make an application, like I said, they will be required to make a commitment. We don't know why they would not. But one of the other issues we have with reciprocal commitments also is the fact that, in fact, it is that particular company or firm or association that applies for duty protection that must make the relevant commitment. So the firm that says, I want protection, they would be the ones required to make the reciprocal commitment. The rest of the industry that are not part of that are not the applicant, they would get to benefit from whatever ITAC would grant them, but they don't have to make any reciprocal commitment. So if you're the one who sticks out their neck and says, I need duty protection, the reciprocal commitment will be put on your neck. But like I said, we don't know what the criteria is to say this firm must make a commitment, which one must not. And that's obviously a bit of a challenge. So one of the questions obviously we've raised is this really a good idea to have a reciprocal commitment? I've not come across, at least so far, any country that does this. So if you need protection, you go to another country and suddenly you're confronted. So you go to your trade investigative body, and now you're confronted not only with your problems that you have in terms of survival, but you also have to give up something when you're asking for duty protection. I think we can move on to the next slide, Donald. We also have an interesting development that has happened, which is the provisional payments provision that has been added to the Trade Act. So there was litigation to this effect. I think it was the TIASA versus ITAC case, which did not go to court. But one of the issues that was raised there was the issue of ITAC requesting for the imposition of provisional payments. The reason why this was problematic, and I won't get into the technical legal language, was that ITAC is a creature of statute, right? ITAC can only do what the Trade Act says it should do. Now, if you read the Trade Act, it doesn't actually say, let me put it this way. When you read the Trade Act, the provision that allows ITAC to request for the imposition of provisional payments, which is Section 30, has not kicked in. So Section 30 would give ITAC the power to say, SARS, Commissioner of SARS, please impose a provisional payment. Because Section 30 is not kicked in, it means that ITAC, technically speaking, under the Trade Act, cannot request for the imposition of a provisional payment. So that was the issue that was raised in the TIASA matter, which was dealt with out of court. But the key thing that is obviously ITAC is clearly conceding that under the Trade Act as it's currently constituted, they do not have the power to request for provisional payments to be imposed. So Section 16.6 will now then give ITAC that power to request for provisional payments to be made. So that's a consequence of the litigation that was launched there. Another addition is obviously the provision on the suspension of duties. So this is quite significant. So the Minister of Trade may request the Minister of Finance to suspend a duty in whole or in part if the particular duty adversely affects the public interest. We don't know what that actually means. Is it the public interest that was mentioned earlier on, or is it a public interest relating to that particular investigation? That's not clear. Also, alternatively, the Minister of Trade can request that the duty be suspended on the ground that there is prejudice to the trade or economic interests of the Republic or SACU. That can be anything, right? So it's the Minister's discretion as to does this violate our, or does this prejudice our trade or economic interest? But of course, like we say there, that really provides a rapid mechanism for particularly instances whereby there's unintended economic harm that is caused by a particular duty that has been imposed. I think let's go to the next slide, Donald. Two other big changes, and maybe let me start with the foreign trade practices remedy. So it seems like we now have a new trade remedy in addition to dumping safeguards, anti-dumping safeguards, and countervailing. There's now a foreign trade practices remedy, which seems to mimic the US Section 301 that I think are currently being investigated on as a country. So Section 18A will include now a foreign trade practices remedy. So what is that really about? It allows the Minister of Trade to take any measure against countries that have either breached a treaty obligation to us, or a country that is denying us as a fair and equitable treatment, or a country that is acting through either its policy or measures in a way that adversely affects our trade or economic interests as a republic, which is the most broadest ground. So the first two grounds of the minister being able to say, I will take any measure to address the conduct of another country that is breaching a treaty obligation. I probably suspect that this is related to the Liberation Day tariffs that the United States imposed on South Africa, that 30% tariff that was imposed on us. And that was clearly a breach of WTO obligations. And there was no way for us as a country to respond in a legal way, right? And this foreign trade practices remedy allows us to be able to respond. Similarly, we could say that we're being denied fair and equitable treatment as is required by the WTO. So the WTO says all countries must be treated fairly and equally in terms of duties, for example. And the way the Liberation Day tariffs were imposed, it was clear that it was not done in a fair and equitable way. Other countries got duties of 5%, 10%, others 20%, others 30%. So there was a clear violation of the MFN obligation, really, that speaks to fair and equitable treatment before the WTO. So I think this is South Africa's way of being able to respond to that problem. Then, of course, a practical change is the requirement that to provide for consolidation of applications. So I think this is a welcome development where ITAC should be able now to consolidate related applications to prevent duplication. So if ITAC realizes that the applications that they have relate to the same parties or relate to the same, and also relate to the same set of facts, in that regard, then ITAC should be able to consolidate the applications in the interest of efficiency. Next slide, Donald. Yes, we also have changes in relation to confidential information. If you see the confidentiality sections that sit within the Trade Act, there was challenges that we've experienced in the past. And of course, we expected that that would be obviously cleaned up. But now there are now clearly stricter rules on how confidential information is going to be handled. Although from what we assess, this seems to be focused primarily on the respondents. An unresolved issue in this regard is whether ITAC should be able to use use confidential information that is gathered in one investigation in another investigation. So we have had that in the past before, and ITAC in that regard did deny that had actually happened. But in our experience, it seems like that's a practice that's possible, and would have preferred that there's a resolution of this issue of whether ITAC can use confidential information that you have submitted in one investigation, and whether it can be used in another investigation. We can go to the next slide, Donald. Also, the additional powers. I won't speak too much about this, but subpoena powers. So ITAC under the new section 41(1)(a will be able to subpoena you That means simply legally compel you to provide oral evidence, that is basically witness testimony, or provide particular books or documents that they need in a particular investigation. Secondly, ITAC will be able to, if instructed by the minister, to reconsider. So if ITAC makes a recommendation to the minister in a particular investigation, if the minister looks at it and says, I don't agree, please reconsider and the investigation and redo certain aspects of it, you will be given a right to be heard. I think that's a significant change. So it's not going to be something whereby ITAC is able to redo an investigation and not be able to hear from you. You'll be given a reasonable opportunity for you to be able to comment. So that's a good change. Furthermore, one big change I think that needs to be highlighted is that there's going to be administrative penalties. Now, this is a big change. If you look at the Trade Act, it does list, I think, from around Section 50, criminal offenses that can be committed under the Trade Act. Now, under the current version of the Act, you simply have criminal offenses, they'll be referred to the NPA for prosecution. What ITAC is proposing here is that, in fact, you'll be made to pay an administrative penalty as an alternative to criminal prosecution. So you can be able to pay an administrative penalty. There will be regulations to this effect that will be published by the minister that will outline the relevant administrative penalties that can be paid for the different offenses under the Act. But what's particularly huge about this amendment is that the administrative penalties will operate as an alternative to criminal prosecution. So instead of being referred to the NPA for criminal prosecution, you can reach a settlement with ITAC on administrative penalty that will effectively bar any further prosecution from ITAC. So that's a big change. The next slide, Donald. Yes, another big change is on the revocation, right, of ITAC recommendations. So this is actually one of the less known powers that ITAC actually has, and I think it's one of the most underused instruments that ITAC has. I won't get into the history of it, but in essence, if ITAC makes a decision, a recommendation, investigation, you should actually technically be able to ask ITAC to revoke or to amend that particular recommendation that they've made in an investigation. So if they've made a decision, you should be able to ask them to be able to revoke it. So the ability to revoke that recommendation sits in sections 28.6 and 48 of the Trade Act, very rarely ever used. But what's happened there is that ITAC has actually improved section 26.6, because section 26.6, the current version, that allows ITAC to revoke or amend its decisions, didn't give you a right to be heard as an applicant or an interested party. Now there'll be a right to be heard. You'll be able to be given an opportunity to be heard if ITAC is deciding to revoke or amend its decision. Secondly, you can also apply. So the current version of section 26.6 doesn't give you a right to apply to ITAC to make the revocation. It only sits in the other provision, section 48. Number three, they've added grounds for you to ask ITAC to revoke or amend its decisions. So the one ground is if there's changed circumstances, so for example, the decision was motivated by a particular set of facts, those facts have changed, you can actually make an application. Furthermore, if you have breached an obligation to ITAC, maybe it's in a reciprocal commitment or as a consequence of the decision that they've made, in that instance, there's actually an opportunity for ITAC to be able to revoke or amend the relevant decision. So that's a very obscure rule, but clearly it probably is going to become relevant as time goes on. The next slide, Donald. What's missing from the Act to close off this discussion, my part of the discussion? Well, still ITAC will not publish its investigation reports as soon as it's done with the investigation. And that causes a whole host of problems in practice. As you know, it means we never know when the ITAC investigation is complete. As soon as ITAC completes its investigations, it sends them to the Minister of Trade. The Minister of Trade, if you approve, sends it to the Minister of Finance. But we can never know because where it sits, because ITAC doesn't publish its investigation reports as soon as it completes it. The report is only published when there's implementation by SARS. And that causes problems because what sometimes happens is that one of the parties to an investigation is able to access the investigation at a time when none of us know whether the investigation is still live or not. Sometimes one can get an oral hearing when you then follow up and say, well, I see that from the public file, this person got an oral hearing. I also want to be able to do an oral hearing to respond to whatever they may have submitted. ITAC might decline that and they say it's not possible at this time. That's typically an indicator that the investigation is complete on the ITAC side, but we're still guessing and we don't know. We would have preferred a provision that clarifies and says if ITAC completes its investigation, they must send it out as to the public as soon as possible. Another problem, obviously, is on issues relating to public file maintenance. The public file, there should be a clear requirement that it must be updated all the time. There is a High Court decision to that effect, that in fact the public file must be regularly updated. And the failure to update the public file has actually caused problems that relate to procedural fairness. That have, like I said, there's actually been a High Court decision to the effect that the public file, failure to update it, actually can violate your right to procedural fairness. And also, significantly, any member of the public should be able to access the public file. It shouldn't be that only the parties that are parties to the investigation can access the public file via appointment. It should be that you should be able to go to ITA Act and just request access to the file, make copies, and be able to get out without any problems. There are also obviously structural gaps that we've picked up from the Act. One, we need an independent review body. It's problematic to have to wait for the High Court. As far as I know right now, if you went to the High Court to challenge an ITA Act decision, you get a date around 2030, 2031. That's a problem. The big elephant in the room that has not been attended to is the Minister of Finance's veto power. As we know in South Africa right now, the person who actually is the final decision maker on any duty protection is actually the Minister of Finance. It's not the Minister of Trade. That issue has still not been clarified. We're still left in limbo as to what the position is. I think, Donald, that should bring my section to the end.
Yeah. Moving to the last two big amendments, I'm going to move through these fairly quickly. And perhaps before I go on, just to say, we are concerned about quite a number of things here. If the regulations get published as they are, plus the amendments to the Act, I foresee all kinds of problems arising in these investigations. So we think it is important to make substantive comments on what is being put out here. So a couple of things. They've introduced in a more direct way this concept of a particular market situation, which is essentially, it's a concept already embedded in the anti-dumping agreement, but a particular market situation says, well, you can't really look at a given country's domestic value of goods in an anti-dumping investigation and the export value of goods and say, well, that situation is perfectly normal. So this is used, for example, quite frequently in other countries when they bring an anti-dumping case against a country like China, where they would say, well, you simply can't use the information on what is happening in the domestic market because subsidies and everything else so dramatically distort the market that you can't simply use the data as provided by the company. Even if that data is correct, its correctness doesn't mean it's an accurate reflection of reality. This has interesting implications, though, because China, of course, is the big offender here. We have an agreement with China called the Record of Understanding, which in fact takes the contrary view to this. That document was signed in 2007, and in summary, it says in an anti-dumping case, if Chinese producers respond, more or less, South Africa will treat China as a market economy. I oversimplify somewhat. So how do these two positions get reconciled is the one question. The other one is there are procedural implications that flow from this. So, for example, if you're in a European investigation against China, you don't even go and gather domestic sales information on China because you say that information is not going to be useful, and they use other methods to construct what they believe would be a normal value. South Africa has an unusually onerous regime in terms of responses, so we're not sure how this plays out into reality. So not to say it's a bad thing, just that it probably doesn't properly account for how things work in reality. And so a little more detail is important. But there are some good things. There's this concept of non-attribution. This is a causality concept. So remember, in an anti-dumping case, you have to demonstrate dumping, injury, and causality. And the non-attribution principle says you can't allocate or attribute injury to dumping, which you are aware is caused by something else. And here they build that out and they say you actually have to more clearly have a look at the effects to these other concepts, and then you can kind of take what's left over, the residual injury, if you like, potentially that could be allocated. So that's an important, very technical issue. On verification, they're tightening up even more rigorously verification of respondents in anti-dumping cases. But there's a really big problem on the other side of this, which is the verification of applicants is incredibly lax. And it creates a situation where anti-dumping cases have been initiated in the past without there being real grounds for those cases to initiate. And companies can incur an enormous cost to defend their interests when there isn't even a case to answer for. So we're worried that all of the focus is on one side, to the point where we could end up in a situation where being able to defend your interests becomes practically almost impossible. Timelines are being further shortened to provide comment. For example, when a essential facts letter comes out, in a sunset review, for example, you'd have 14 days to comment. They've now cut it down to 7 days. We've requested on many occasions that ITAC be legally obliged to give the calculations for any given company that responds. When they work out that company ABC in Belgium has an anti-dumping margin of 10%, that they be legally obliged to share those calculations. That is still not written into the regulations. We've picked up enormous errors in these calculations in the past, so we see this as a really big gap in the process. There's all pretense of having to issue complete and accurate verification reports has been removed. They've now said verification reports don't need to be complete, and if they're incomplete, the Commission can still consider information which was verified and not written up in the report. So you can imagine a situation where you've got a complete information asymmetry between what the company being verified knows and versus what the Commission may be presented with. Currently, when ITAC raised deficiencies in an anti-dumping case, you have a hard 7 calendar days to respond, no matter if there are weekends, public holidays in between. We've raised this before with them, but extensions have to be permissible on deficiency letters. So we've had cases in the past where deficiency letters would come out right over the Christmas period, for example, or right at the beginning of the Chinese New Year, where nobody can actually deal with things, and you've had companies kicked out of investigations on what we would consider ridiculous procedural grounds. The anti-circumvention framework has been tightened up. I think this is more good than bad. There's some technical questions on how duties are going to be calculated in this new framework, but they are tightening this up. This is an enormous problem in anti-dumping cases. If you put the duty in and people end up not paying it because they circumvent it, and so I think that's just generally a good thing. We have some problem with sunset reviews. These are the reviews that happen after 5 years. The biggest concern we have, particularly with sunset reviews, and I guess not really on the slide here, is that there is no obligation on ITAC to verify an applicant's information if it is a sunset review. This appears to be nothing more than a lacuna, but it is a really big problem because it allows potentially applicants to be less than honest or misrepresent information in an anti-dumping sunset review. And this is not something that has never happened before. Removing the requirement to verify creates an incentive that can be quite concerning. Many of these other issues are quite technical. I'm gonna just sort of skip over a lot of that. Our biggest concern, I think, out of all of this is what is missing rather than what is being proposed. So there are some things on how things are worded which could be worded better, but there are very, very big issues that are simply not present in the regulations. And some of them, like Clive mentioned earlier, for example, the role of the Minister of Finance, these have been clarified in court cases before. They have to be included in the legislation rather than requiring respondents to know about an obscure court case. If we quickly get to safeguard regulations, safeguards deal with sudden, large, unpredictable surges in imports, and that they're kind of the atomic or the nuclear option in defensive instruments. They hit the whole world that you were trading with. It could be as big as they need to be, incredibly disruptive. And they've tightened up a few things. For example, the question of causality. Is the injury caused by the surge? We had a case a couple of years ago where a company had closed down their factory for 6 months, but the causality was still attributed fully to the imports, rather than the fact that imports are, of course, going to surge when the only producer doesn't manufacture. So there are significant problems with the old framework. We think these are good amendments, but there are, again, things missing. Safeguards don't have a mandatory expiry date. Anti-dumping actions have to expire after 18 months. We've had a safeguard investigation in the past that ran on for almost 3 years. Bear in mind, this is meant to be an urgent intervention. So we believe we should have a limiting. Interestingly, if you apply for an extension in a safeguard, they have 12 months to complete it. But in a primary investigation, they don't. I'm going to skip through because I want to leave you guys some questions. This is without a doubt a shift to a more protectionist environment. That's fine. From a policy perspective, our concern with this is always in the process. How will the process unfold in reality? Are the investigations going to be fair, or are we going to be in a position where companies can be penalized simply because they got something wrong with their paperwork, rather than because substantively there is a problem? So I'm going to keep quiet at this moment. Any questions? Let's see that. Gerard, thanks so much. If possible, could you please mention how or if ITAC is applying BEE as permit gates for authorizations? Where do you see it going? Yes, so this is explicitly written up in ITAC's proposed annual performance plan for this year. So permits arise for many different reasons. You can, all sorts of reasons you may need to get a permit, and a permit does exactly what it says, which is you need permission from ITAC before you can import, export, whatever. ITAC have explicitly said that they will be including BEE as a consideration when permits are issued. Now, how that will be considered, we're not exactly sure yet, because they haven't given detail. That does not appear in any of these proposed amendments. So it's not as if they've written it into the law anyway. But the problem is that the legislation and sort of regulatory environment around permits is really loose. So ITAC can pretty much attach whatever condition they wish to a permit, and they can decline the permit if they're not happy with whatever you've given them. So I don't like this at all, because I think it becomes very unpredictable. We don't know what the rules will be. We don't know for certain kinds of permits, will this apply, will it not? But I would be very surprised if this does not become part of the policy space, if not the legislative space in this year. In other words, I think they will begin applying this in some way, but I don't know what the detail will be. We are looking for companies who are concerned about this to please contact us. We are looking to put together a concern on the legal issues. if you have a concern, please get hold of us. We'd love to include you in a consortium that does a response. I mean, just to kind of go back to something I said at the end, the point of this is not to say that there's a problem with the direction of travel, but we want to ensure that everybody who participates in a case, whether you be the applicant or respondents, has a fair and predictable process ahead of them. We get very worried when the process gets tilted in one direction over another. Leanne, nice that you could join us. In respect of the application for revocation and amendments of recommendations, will you be able to apply for them, for example, in duty reviews which were issued before these amendments? Clive, I'm going to ask you to answer that, if you wouldn't mind.
Yeah, that's a technical problem. It's a technical question because, legally speaking, the law doesn't apply retroactively. So, in other words, the law doesn't get created to change the circumstances for past conduct. And the reason why we don't, the law doesn't allow for the law to apply going into the past is because, you know, the people, whoever was engaged in particular conduct, it would be unfair on them to not know the consequences, or to think that the consequences of their action might change in future, and without them knowing what those consequences would be. To say it in simpler terms, the law normally would not be used in a way that changes previous investigations. For that to happen, then ITA would have to be in the provision specifically say this actually applies even into investigations in the past. So I think the short answer would be no, it would not. The law is supposed to apply from the moment it kicks in going forward. It doesn't apply to previous conduct. The only way to do that is if that particular provision in section 26.6 actually says it applies to investigations that have already been concluded in the past. Does that answer your question?
So Theo raises an important issue here, which is more of a comment than a question, but the national security provisions seem to go contrary to our stance in favor of a rules-based WTO system. It almost seems like a case of, if you can't beat them, join them. Clive?
Well, I think to start off with, the national security is part of the WTO framework. So countries are allowed to use national security, but the grounds for using national security are not what we are doing it for. National security under the WTO is essentially for threats to your public law and order, threats to the stability of a country. So these are instances whereby, for example, there might be an insurgency, there must be armed conflict or some sort of latent conflict in the country. So anytime national security is raised within the WTO context, it is only in respect of matters relating to collective security, matters relating to war, armed war, latent war, instability. National security is not supposed to be used for economic problems. If you have an economic problem, you use a safeguard mechanism. So I guess indeed, yes. I guess, Theo, I think actually I do agree with you that in fact we are not using the instrument the way it's supposed to be used. The instrument is supposed to be used only for instances whereby there's a threat to essentially public law and order, and that could be like a war and everything. For economic emergencies, you have to use the safeguard trade remedy.
Theo asks another very important question. Do you see any benefit in asking for automation to be brought into the Act, such as when the trigger is picked up, like on sugar or wheat, etc., until the tariff is put in place? So Theo, I can't really comment, maybe ask Clive to comment on whether it can be inserted into the Act. We've been extremely concerned by just how poorly the triggers have been dealt with in the past. This is something we've raised repeatedly. It has improved a bit, but there are still many problems with it. So I'd be hugely in favor of something like that. If you like, I can also show you. It's maybe not appropriate for now, but it is worth looking at. We've already explored how that could be done, and it's relatively easy to do. The problem, though, is not just a technology problem. The other side of this problem is that there's no legal commitment on how fast from when a trigger is hit to implementation. So ITAC had agreed in the past that, Clive, just correct me if I'm wrong here, I think they'd made a commitment in one of the court cases that they would get the sign-off within 24 hours of the trigger being hit. And I think the minister said within, was it a week of receiving the trigger notice, he would make a change. But then when it got to the Minister of Finance, he refused to commit to anything. I think the technology is only half the solution here. Clive, question for you. Is it not permissible as things stand for ITAC to do a joint investigation into two products?
I think, Donald, you're probably better placed to answer that question.
The answer is yes, they can, but the products have to be fairly tightly related. So yeah, I mean, the answer is yes. It's not uncommon to look at a steel case and have many different tariff codes or chicken or whatever the case might be. So the answer is yes, it is permissible. Theo asks, is there any appeal or review process in relation to administrative penalties? We have had bad experiences with the ATO system whereby somebody can play accuser and referee. Very good question. Clive?
I'm not sure at present. The provision doesn't seem to provide for that, but my sense is, in any event, all these are subject to a review before the High Court. So all ITAC decisions anyway have to be reviewed by the High Court. So there would always be an opportunity to review, because the way the Trade Act sets it up is that ITAC decisions are all administrative decisions, and they can be reviewed. So if you look at the new proposal now to be Section 47, it does say that you can appeal a decision of ITAC to the High Court.
I think, Clive, it may be, we're not going to have time to deal with it here, but it may be worth noting that we have a concern that we don't have an alternative dispute resolution system with ITAC. So, if something goes wrong, whether it be a decision or a penalty, whatever the case is, your only mechanism is to go to court. So there's kind of a newer proposal they've put in here where you could sort of appeal to the minister and say, well, this was wrong, can you send it back? But I'm hugely in favor of something which is outside of ITAC, where you can appeal things. Small companies are largely removed from being able to appeal anything because the cost of going to court is so prohibitively high. There should be a much cheaper mechanism, especially as ITAC becomes considerably more active in the market. Paul says, Clive was unsure what adversely affected means. This is standard terminology that dates back to the days when South Africa was influenced by the UK methodology. So it is pre-1960 and definitely pre-Competition Commission. I don't know if you have a comment on that, Clive?
No, that's fair. I'm not sure. So I think I would leave it at that. I think it's probably something I would look into. I think maybe the only thing I can say to that is they would have to explain what it means, particularly in this context. I know it's used in the Competition Act, but as Paul says, that it predates this particular dispensation. So I accept that, and I'll probably do some more research on it. But ultimately, when it is adjudicated upon or decided upon, they would simply look at what does it mean in this particular context. I think that's the one thing I wanted to say. The other thing I wanted to speak to briefly was the issue of the administrative penalties. There will be regulations to dealing with this particular administrative penalties. So this is not the end of it. So if the provision survives and it is kept in this form, the minister is still going to make regulations on the procedure for the imposition and the payment of these, the criteria to be considered, the maximum amounts that will be paid, and so in terms of, if it's this offense, this is the penalty. And it's at that stage, I think we will also have to make sure that we find a way to make an argument for appeal or review of those particular administrative penalties and what should happen in that respect. So it's not over as yet. This would be the first part of it, which is putting it in the Act. There will be regulations that actually deal with these administrative penalties. And I think some of the issues that have been raised about, for example, the ITA system, we can actually be able to address them then when the draft regulations come out.
Good. I think we are going to close up. Anyone who wants to be part of our response, please get hold of either myself or Clive. Thank you very much. If you have questions you were not comfortable asking here, feel free to get hold of us offline. Thank you, everyone. Bye-bye.